Good afternoon, everyone. Here we are, noon hour of September 23rd, 2020, 12 Points Wealth Management. And my name is Christopher Cahill for our monthly webinar, Essential Legal Documents for Every Family. I'm honored to have with me today Andrew Butler from Archstone Law Group. Andrew and I will get going in just 1 minute, but I see other attendees just rolling through, and I know there's a bunch of folks signed up for this today, so we want to give them just a minute more to get in, but we do want to be respectful of your time today. We're going to try to get this program in and out in and around 30 minutes or so. Certainly available to take questions after, but we know that you're busy and there's a lot on your plate. So we want to just make sure that we're providing you the information that you're interested in a thoughtful, timely fashion. All right. So Andrew, without further ado, let's actually just get started. We've got about half of the folks that said they were coming in already, and that's generally a pretty good showing right there. So as I indicated, my name is Christopher Cahill, and here you see my photograph. I'm an attorney by training and background. I'm also a certified financial planner and a chartered advisor in philanthropy. I run the Family Office Services Group here at 12 Points. Working with all manner of wealthy families. I have an expertise centered around working with partners at major law firms, business owners, other wealthy families and individuals, and really work at the intersection of wealth, planning, and philanthropy. So I'm very, very honored to have with me today as a co-presenter, Andrew Butler, partner at Archstone Law Group in Newton, Mass. Andrew focuses his practice on estate planning and estate administration and elder law. He's been doing this for over 25 years and has assisted individuals, couples, and families to meet their estate, financial, and tax, long-term care, and retirement planning needs. Andrew's background is really interesting. He is a graduate of the Wharton School of Business at Pennsylvania, and then he went on to Georgetown, where he has his law degree and his master's in taxation, his LLM. So eminently qualified to be talking on these subjects today. And Andrew, thank you for joining us.
Thanks, Chris, and thanks for that introduction. And I think given the time, we should just jump right into the material here.
Wonderful. So we're going to talk about estate planning, everyone's favorite topic. One of those things that many people think about and kind of put on the back burner and don't get around to. I think the pandemic has taught us all that we need to pay attention to things that we might not want to sometimes. So now is a great time, as we said in the intro, to dust off those legal docs if you have them, take a look at them, see if they need to be updated. And if you don't have them, we're going to talk about the documents that you ought to have. So we're going to really cover today the basics of wills. Primarily, this is Massachusetts-based discussion, but certainly these documents are covered in other jurisdictions very similarly. We're going to talk about living trusts, what we also call revocable trusts, powers of attorney, HIPAA medical directives, advanced medical directives, and healthcare proxies, and what we call HIPAA authorizations, and then lastly, irrevocable trusts and prenuptial agreements. So without further ado, Andrew, let's get into step one on the journey, wills.
Sure. And thanks again, Chris. So wills are probably the document that people most, when you hear the word or term estate plan, I think will tends to jump to mind first. And it, arguably is maybe the most essential document, but the other documents we'll talk about are, I would say, really equally important as well. So we'll start with the will, but don't take it as kind of the end point. The other documents really are really important. So wills accomplish a few things. It's where you provide for the distribution of at least some of your assets. Assets fall into two categories. They're what we call probate assets, which pass under your will, and then non-probate assets, which actually don't pass through the will. And I think that's a really important distinction. So non-probate would be jointly owned assets, such as a home or a joint bank account, retirement accounts that pass according to the beneficiary designation, and life insurance policies, which again pass according to the beneficiary designation. So I think it's just a really important distinction. If you take nothing else away today, kind of the importance of sort of probate versus non-probate. So in addition to assets, a will is where you would, if you have minor children, it's where you would name a guardian for them if something happens to the parents. And it's also where you would name a personal representative of the estate. A lot of people think of the term executor, but the terminology in Massachusetts is personal representative, but it means the same thing. And we also, in addition to kind of the bulk of the assets, the will is also where we might make a provision for what we call tangible personal property, which are personal possessions such as jewelry, artwork, automobile, kind of those personal items. So that's what a will does. Different types. You could have a simple will that kind of does all the work for you. And then in a situation where you're going to utilize a trust as well, and we'll get to that next, you would have what's often referred to as a pour of a will, which would pour over your probate assets to your trust at your death. So those are the different types. Quickly, in terms of requirements, a will in Massachusetts needs to be in writing. You need to be 18 years of age or over to execute one. At that time, you need to be of sound mind and not under any undue influence. And there needs to be at least 2 witnesses to the signing. Just a quick point, since the law was passed back in April, which is now allowing us to do what we call virtual signings, virtual notarizations, virtual witnessing. So I've been spending a lot of time on Zoom, both meeting with clients and also handling the signing of documents. So hopefully that law will be extended even beyond the current pandemic, because it's been a really helpful to clients. So
absolutely, and it's really taken a lot of the stress off of families that have elderly parents, maybe that are, or anyone that's concerned about contracting COVID here, that want to do documents but are somewhat reluctant to be out in front of other folks. So this is just a nice way to be able to get that done, right?
Yeah. So the law is supposed to, the way it was written, it will not go out of existence when COVID goes away. But we're really hoping that Beacon Hill will extend it permanently. So we'll see how it's.
Sure. So one other question for you, Andrew, as it relates to wills here. Let's talk for a moment about what would happen if you didn't have a will in Massachusetts, the laws of intestacy. So, you know, we don't need to get into the specifics, but just, one thing that people ask me oftentimes is, what would happen if I pass away without a will?
Right. So just to clarify one sort of misconception out there is that it would not mean that your assets would go to the state. They would not go to.
Great point.
They would not go to Charlie Baker or somebody else on Beacon Hill. They would pass according to, as you mentioned, the laws of intestacy, and basically it means it would go to your closest living relative. So if you're married, for the most part, it's going to go to your spouse. If you have kids, and you're don't have a spouse, it would go to them. Parents, siblings, etc. So it, in a lot of cases, it might go to, certainly going to go to people in your family, but the point is that it would not, you're relying on what that statute says as opposed to, you indicating where you want it to go. So, you may not want it to go to, what the statute says and what your wishes are may, in many cases may not be the same. So, but better to take control.
Certainly, yeah, and particularly with regard to naming of a guardian, I mean, you definitely want to be able to be in control of that. I find
naming
more
of a guardian.
So.
Yeah, and also the naming of a personal representative. Who the person who's going to administer your estate. You want that to be somebody that you really trust.
No doubt. So let's pivot and continue to the world of living trusts, what we also refer to as revocable trusts.
Right. So as I mentioned before, in a plan, utilizing, a trust, the will would be a pour over. So it would sort of send any assets that hadn't already gone into your trust during your lifetime. It would add them in at that point. So why do people use a living or revocable trust? As you see here, there's a number of benefits. So it allows for sort of better control over your property, both during your lifetime, particularly during a period of incapacity, and
Yep.
also after your death as well. There's no sort of kind of size, sort of minimum or maximum, really. Really any size estate, a trust could be appropriate. One of the benefits we talk about a lot is that it can help avoid probate on your assets. I talked earlier about your probate assets passing under your will. If you die with probate assets, you have to go through the probate process, which involves filing the original will at the court, an original death certificate, a number of probate court forms, and paying a fee to the court, and also probably paying a fee to a lawyer to help guide you through all of that. That will cost money. It will take time, but if you've already gotten those if you've changed those probate assets into non-probate assets during your lifetime, for example, by retitling them in the name of a living or revocable trust, which you had set up, you can avoid probate. So it's, as I mentioned before, particularly during a period of incapacity, having some, if not the bulk of your assets in a trust, really makes the management and sort of the utilization of those assets much easier than if they're not in the trust. Without that, you would have to rely on someone dealing with those assets under a durable power of attorney, which we'll talk about in a few slides after this one. That works, but it's really not ideal, particularly over a long period of time. Better to have it in a trust. And maybe not applicable for everybody, but for many people, the estate tax may be relevant, particularly the Massachusetts estate tax. And a living or revocable trust can allow us to do some pretty significant estate tax planning. One more, misconception I want to just speak to quickly, which is I have people who come in and say, oh, if I put all my assets in a revocable trust, there won't be any estate tax on them. That's not,
or that only true, right?
Yeah, exactly. I mean, if there were such a easy solution, that would be great. But what a living trust does allow you to do, or allows us to do, is to take advantage of certain estate tax exemptions. And again, it's sort of beyond the scope of today's discussion, but I just wanted to clarify that. A couple of, I guess, downsides to a living trust. Obviously, given that it's an additional document, additional work, the legal fee you're going to pay is going to be higher. And again, unless you fund the trust, during lifetime and make provisions for it to do any final funding after your death, then it's really not worth your while. Like you can have a great document, but if you haven't set it up to if you haven't put assets in there, set it up to receive more assets when you've died, then it's really not going to be worth it to you. So.
And I can't tell you how many times I've seen that. I'm sure you have as well, Andrew. But we
Sure.
have clients come to us with really wonderful documents, cutting edge stuff. They spent a lot of money on them. They were very thoughtful putting it into place. And then they just simply dropped the ball. Either they did, their attorney did, or their financial advisor did on the actual funding of the trust. So to your point, I mean, it's once you get it done, you need to fill it on up. So you get the trust done. You transfer your assets in there to the extent that you can, and then the document will really be as effective as it possibly can be, and that's really what we're looking to do with all of our clients.
I often think of an estate plan as just being sort of one part of a family's or individual sort of overall kind of, call it sort of financial or kind of life puzzle. And And kind of to your point, so these documents, in particular the living trust, really needs to be coordinated with those other pieces of the puzzle. So,
no, that's a great term for it. I really get behind that. And it's just important to have a team of professionals that are geared towards putting your interest as the client first and foremost, and that they know one another and they work well together like Andrew and I do. There's a lot of collegiality, a lot of respect and friendship there that's important to have between advisors, so that you can pick up the phone and say, hey, did that get done? And say, oh yeah, it did, or oh, I'm about to do it, or whatever. So you just want to have what I like to refer to as that intentional team of advisors, people that are put together thoughtfully to work on your behalf and to make sure that that everything is being done as it ought to be. So let's pivot now and go to the next topic here, Andrew, which is powers of attorney. But before we get fully in here, I think that you touched on something a moment ago with the revocable trust that I just really want to put a real emphasis on. The revocable trusts, when you have somebody that's incapacitated and there's a successor trustee serving as the trustee of that trust, they're going to get a whole lot more deferential treatment from all manner of financial institutions, whether it's custodians like Charles Schwab, Fidelity, Vanguard, or whomever, TD, and banks and other institutions. If by chance you don't have your assets in a revocable trust, and as Andrew indicated, you need to rely upon a durable power of attorney, those institutions, when you walk into a bank with a durable power of attorney, people are going to step back, and they're not really going to want to deal with that document. And next thing you know, you're really in the world of having the attorneys at the bank and at the firms, financial institutions, interpret them, look at them. It's just a totally different conversation. It shouldn't be that way. It is. So, a power of attorney is critical. You should have it, and I'm not saying that you shouldn't, but I definitely just want to reiterate what Andrew indicated a moment ago and said a moment ago, which is having a revocable trust, particularly for people that may be incapacitated in the future, and let's face it, none of us know if we're going to be that person or not, is really, really important. So let's go here, Andrew. What are your thoughts relative to powers of attorney?
Sure. Yeah, so we're sort of pivoting here from, the will and the trust. We're kind of dealing with the assets and, primarily kind of what happens at death. Now we're kind of turning to the topic of incapacity during a lifetime. So, if you were to get very sick, be involved in an accident, perhaps develop dementia, and so there's a period in your life where mentally and or physically, you just sort of can't keep up with kind of your day-to-day affairs. A power of attorney, and in particular a durable power of attorney, is incredibly helpful in that situation.
Mm-hmm.
So generally speaking, a power of attorney, you're sort of giving somebody else the authority to act for you. But normally, a normal power of attorney, so reference here is a non-durable power of attorney, if the principal, so the person granting the power of attorney, if they become incapacitated, the agent can't act anymore because they're treated as being in sort of the same state as the principal. So by statute, Massachusetts, and I think really every jurisdiction in the country authorizes what's called a durable power of attorney. And the durable portion refers to the fact that it survives incapacity. So is durable in that regard. So even if the principal becomes incapacitated, the agent can still act. Okay. Now, while these are intended to really only be used during a period of incapacity, the way we typically draft them is they actually become effective the moment they're signed. That they don't require a determination of incapacity. And the feeling is that, given the nature of what might need to be done here, paying someone's bills, filing their tax returns, we don't want there to be time lost where we're trying to provide sort of proof of that incapacity. I mean,
Mm-hmm.
The feeling is if you're naming someone that you trust, the feeling is they're only going to act when they really need to. And we don't want to put something in there that's going to slow things down by requiring, a doctor to sign off on something or, some order from a judge or something. Meanwhile, bills are accumulating, tax returns need to be filed. maybe business needs to be managed, and meanwhile the power of attorney doesn't have authority. So we typically have them become effective the moment they're signed. It's a good idea to have a primary, name a primary agent as well as a backup. And just quickly, sometimes I've had clients who might name one person to do most things under the power of attorney, but they might have a limited or special durable power of attorney, perhaps for a business. So maybe they're going to have somebody in their family deal with their kind of personal stuff, and maybe they have a business partner who they give their power of attorney relative to the business. And we can kind of,
excellent,
those two different documents working together.
And to your point, you just need to make sure that whomever you're giving these powers to is somebody that you trust implicitly, because you are granting them the legal authority to step into your shoes. So by all means, be careful about that. And let's take a look at the next document. So if the durable deals with finances, these two documents kind of deal with the medical side of the ledger, right?
Yeah, these obviously have been, I think, given the last, 6 months or so, I think have, really shown the need for the importance of these. So, probably most people have heard the term healthcare proxy. So it's like the durable power of attorney, it's a statutory document, so authorized by statute here in Massachusetts, where you name someone as your healthcare agent who has the authority to make medical decisions for you in the event you're unable to express your wishes yourself. So, you end up as a result of a, illness, perhaps, COVID, or you're in an accident, whatever it may be, you're in a hospital or nursing home setting, medical decisions need to be made, and you're not able to tell the medical providers, what you want or don't want. So you're giving somebody, that authority to kind of be your voice. If you want to give that person, and I think it's really important, if you want to give that person some guidance, I think you can take a couple of approaches to that. So one is, if you're, feel comfortable and this is something that appeals to you, you can put something in writing, sometimes referred to as a living will or an advanced medical directive. And we have the term, we have the phrase legal document in quotes here, because while it might look like a legal document, in Massachusetts, a living will or advanced healthcare directive is not a legally binding document. There's no authority behind it. A judge will not enforce that. But not a reason not to do one, because I think you want to give your healthcare agent a good idea of what your wishes are. And so, if it works for you, putting that in writing can be helpful. What I think is, to me, what is sort of more the gold standard, I think, is really to talk to your agent, you'd probably want to have a primary and a backup. So really talk to both of those people. And this is an ongoing conversation, because your feelings may change over time. Not an easy conversation to have, I will grant you that. There's a really good resource out there that I refer clients to all the time, which is called the Conversation Project, and their website is theconversationproject.org, based here in the Boston area, and it really gives you kind of the language to use to kind of start those conversations. So I would encourage you to take a look at that. Again, conversationproject.org.
Excellent, thank you for that. And
maybe we can just flip to the next slide here, as I see we're getting kind of close to 11:30 or 12:30. Want to be conscious of people's time. So in the same context, another important document is what's called a HIPAA release. So this comes out of some regulations, the Health Insurance Portability and Accountability Act, which is, I think, about 15 years old at this point. And this is all the stuff about patient privacy. So you're at the doctor's office at the hospital, you see all the signs about, that they won't, share your information, unless you give them written authorization. So if you find yourself in a situation where your healthcare proxy has been invoked, your healthcare agent is making decisions for you, you really, it's really important that doctors, nurses, et cetera, can talk to your healthcare agent and share your personal medical information. So again, I have all my clients, when they sign the healthcare proxy, I have them sign the HIPAA release as well. And we literally like stick documents together because they really go hand in hand.
Yeah. Yeah,
and it's a good idea.
In a world of hurt without it.
To actually give a copy to your primary care physician and have them actually put it into your medical record, so it's there if and when the time comes.
No, that's a great idea, Andrew. And these three documents that we just discussed here, the durable, the healthcare proxy, and the HIPAA authorization, these things are critical for anyone, even those without any assets at all. So, we have many of our clients have children that are coming up and coming of age, and my kids are both now at college, and as soon as they hit age 18 in Massachusetts, it's really critical that as a parent you have the kids sign these documents, because otherwise you can't make decisions for them. The physicians and nurses want to communicate with you, but they can't. So it's a real important thing that's often overlooked, to have your children and those people that you're close with, when the kids hit 18, 19 years old, heading off to college, make sure that you get these documents. In today's world, even more importantly. So let's pivot and go to irrevocable trusts here, Andrew, and we can go over an extra couple of minutes. So let's not give this short shrift here, because this is really important stuff.
Right.
So irrevocable trusts is as it relates to planning versus revocable trusts.
Sure. So, it's obviously, the important, you can just tell from the names, one important difference here is, revocable means that you can change anytime you want. If you put assets in there, they're still considered yours. You can take them back out. Irrevocable, on the other hand, once you put something in there, we can build some flexibility in, but for the most part, think of it as once you put it in there, you're not going to be able to get it back. And again, there's some exceptions here as well, but whatever the terms of that trust are, you're probably not going to be able to change them. Although we are now able to do something called decanting of trust here in Massachusetts, where we can, if we have a trust we don't like anymore, we can kind of decant the assets that are in there, kind of pour them out of that trust and into a new one that we like better. So, but I don't think you want to sort of rely on all of that stuff. I think that the point is, think of it as once it's in there, it's not coming back out, and whatever that trust says, it's probably going to say that same thing indefinitely. So irrevocable trust is used for a number of reasons. I would say the primary one I see in my practice is for people who have I would say modest to significant estate tax issue down the road, potential issue. It's a way of reducing their estate, because once you put the assets in there, they're not yours anymore, and so they're not going to be subject to estate tax. And that's really particularly helpful in a state like Massachusetts, where there's a low estate tax exemption, only $1 million. But at the same time, there's not a gift tax. So if you give it away during your lifetime, Massachusetts won't tax you on it. But because that exemption is low, the need to reduce your estate is that much higher. So it really makes a lot of sense here in Massachusetts. So there's the estate tax advantage. There potentially can be income tax advantages because if you don't own the asset anymore, you don't have to pay the tax on it if it's an income generating assets. You also sometimes hear of irrevocable trust used in the context of long-term care planning. So people may have heard the term like a Medicaid trust. So again, that's way beyond the scope of today, just because we could spend hours just on that one concept. So but I just would want to throw that out there. I would say the probably the one asset, or the asset that we most often put into an irrevocable trust is a life insurance policy. Because maybe contrary to what you might think, even a term insurance policy that has no economic or financial value while you're alive, it is still subject to estate tax at the time of your death. And because how you own an insurance policy isn't really what's important. It's the fact that you have the coverage, and that if you die, that the money will go to your family. So owning it isn't really what's important there. It's just that you have the policy. So we can create what's often referred to as an irrevocable life insurance trust. And so we use the acronym ILIT, I-L-I-T, and we have that trust own the policy. That gets it out of the estate. At your death, the policy would pay off and it would go into the trust, and the beneficiaries of the trust would be, your family members. So, perhaps a surviving spouse and children. So the money will still go to the same people, but not reduced, by estate tax at all. So that's probably the most common form of irrevocable trust that we see.
And we could probably spend 2 hours talking about irrev trusts ourselves here, but in the interest of time, let's just say that any of you that are interested in any of these topics, by all means, reach out to myself, reach out to Andrew directly. We'll show our contact information again here in a moment as we wrap up. But the one question, Andrew, before we get into just closing with prenuptials and postnuptial agreements,
Okay.
really important to understand, what is your view as it relates to, say you have a client that has these documents, do they just pack them up, put them in the drawer and never look at them again? When should they come back to you? When should they come and talk to me about what, possibly reviewing and updating them? What are the triggers in your mind on that?
Yeah, no, I think that's a really important point. I think there's a tendency to kind of, sort of do the estate plan, check the box on it, and say, oh, I did that. I don't have to think about it again. And so I would say there's a couple points here. So one, at a minimum, I think it's a good idea. I think the rule of thumb I say to my clients is somewhere in the 3 to 5 year time range, is just to check in. We can do it, by phone, by Zoom these days. Just kind of walk back through the documents, kind of find out where you are at this point, and just make sure everything, still makes sense. The decisions you made in 2015 are still the same decisions you want to make here in 2020. So that's kind of just, sort of somewhere in that 3 to 5 year time range, just to do a review. But in between, but short of that, if you have a significant sort of life change, so change in marital status, you get married or you get divorced, you have a child, you retire, you sell your business, you move, I would say particularly, an out-of-state move, moving from one neighborhood to another, although might be worth at least a check-in. So just kind of those significant kind of life, financial, family events that might come up. Just, good idea just to check in and say, hey, does this, is the plan still work for me? So.
Absolutely. So let's just round off real quickly here. Oops, wrong way. Sorry about that. With prenuptial agreements, let's talk about them for a moment, a post-nup, and then we'll be done.
Right. So I just mentioned, kind of change in marital status, marriage or divorce.
Yep.
So I guess a prenuptial agreement is kind of the intersection of those two things. So, just very quickly, because again, this is a big topic, but very quickly, I think people hear the term prenup and they think that's just like the most unromantic, like worst thing to be thinking about, before you're about to get married. And I guess, I don't want to say that it's a prenuptial agreement is romantic. On the other hand, though, what I view a prenup agreement is a way of just kind of making the arrangements, making the deal ahead of time if things don't work out right. So in the same way, if you were going into business with somebody, signing a contract with somebody, you'd want to know, if we decide to go our separate ways with this, partnership, this business, here's how things will work. And so same thing, if the marriage doesn't work out, let's just go ahead and kind of make the arrangements now so that we're not going to, in an emotionally charged time, we're not, dealing with, lawyers and lawyer fees and negotiations. Let's just take care of that stuff ahead of time. And then, what a prenup will get into is, what happens to assets. And there's usually a distinction between assets that, each party brings into the marriage versus assets they acquire during the marriage. It might very well talk about what happens with assets that that somebody inherits during the marriage, and also what would happen if one spouse died during the marriage. What provisions do they want to make for the survivor? let me just go to the next slide here. Again, spousal financial rights. So it's kind of a way of talking about, again, how things get divided up. It might also talk about, make provisions for alimony. You know, is there going to be alimony? Is there not going to be alimony? And then protecting, you know, each spouse from the other person's debts. You don't want to get divorced and actually, you know, take on somebody else's debt. Not a fun thing. When to include lawyers, I would pretty much
all the
say
time, right, Andrew?
Yeah, I would say if you're going to do a prenup or even talk about a prenup, you almost have to have a lawyer.
Oh, for sure. You can't do this yourself. You can't.
Yeah, if you want it to hold up down the road, you really want to have a lawyer, and it's actually, and lawyers, meaning each party needs their own lawyer. You can start with one and kind of get to maybe the 20-yard line with one lawyer, but to get all the way to the end zone, each side will need to have their own. And the slide here mentions post-nuptial agreement. So you actually could wait and do the agreement after you're married, but you know, definitely
that can be a tough discussion.
Yeah, because a prenuptial agreement is, if it's done properly, is presumed to be enforceable, whereas a postnuptial agreement is the opposite. A party wanting to utilize it has to prove that it in fact is enforceable.
So we're going to wrap up here. If there are any questions, this is where you can reach me. We're here to help. Christopher Cahill, as I said, my email is chris@12pointswealth or 12points.com, either. Phone number.
Great. And I may have lost my sound. If you can hear me, you've got my email and phone numbers there, office in Newton, but it's really just on Zoom these days. And really appreciated having this opportunity today, and wish everybody the best. Stay well.